Here is a detailed, legally grounded rebuttal to the misinformation and misapplied statutes you've encountered. Let me know if you want to refine this further or use portions for filings, social responses, or formal legal communication. Here is a direct, legally informed rebuttal to the misinformation presented in the troll commentary. This version is appropriate for legal response, public clarification, or evidentiary framing. Rebuttal to misstatements on code enforcement, housing rights, and tenant displacement. 1. Code enforcement only targets property owners, not tenants. Misleading. Legally, the enforcement action may be against the property owner, but intentional displacement of a specific person via selective enforcement is a constructive deprivation of that person's rights. When the tenant is named, cited, or referred to as the problem in communications, and the only proposed solution is for them to leave, then the target is not the property, it's the person. 4 documented incidents include Chad Gray threatening to bulldoze properties where I lived, owners being told I was the reason for enforcement, not any unsafe condition, emails from the county showing targeted interest in my presence, verbal and written pressure from authorities to landlords implying continued housing would bring inspection or liability, legal principle, under 42 U.S.C. Product 1983, any government actor using official power to coerce third parties, e.g. landlords. To deny someone housing constitutes state action and can be challenged as retaliatory deprivation of liberty or property interest. 2. You can't have tenant rights if you live in a garage, RV, or non-residential structure. Half true, but incomplete. Even if a unit is non-conforming, landlord-tenant law does not require the dwelling to be zoned as residential to trigger basic rights. If rent is paid, money or barter, and exclusive possession is given, Colorado courts often recognize a de facto tenancy. See People v. Lubau, 675 P2D, 2 Hap 1983. Occupancy agreements not conforming to code may still confer protections. Retaliatory eviction stat 38-12-509 apply regardless of zoning status. Constructive eviction doesn't require a lease, only proof that a person was forcibly deprived of housing access. 3. He left voluntarily, so there's no eviction or duress. Legally inaccurate. Voluntary departure under threat, coercion, or constructive duress is still actionable. I left only after landlords were pressured or threatened. In no case did I receive formal eviction notices. I was removed in reaction to external county pressure, not lease violations. This is constructive eviction, not voluntary relocation. Burt v. Beautiful Savior Lutheran Church, 809 P2D 1064, Colo App, 1990, supports claims where a party leaves due to intolerable pressure caused by the landlord or external threat. 4. RV or garage living violates zoning. No rights apply. Wrong application of law. Zoning violations may justify code enforcement, but they do not erase the obligation to follow due process. A tenant still has the right to notice, a hearing, and cannot be summarily displaced just because the use is non-conforming. Thomas v. Fick, 164 Colo, 404, 1968. Even unlawful occupancy does not justify self-help eviction. In multiple cases, I was told I had to leave without judicial process just because I existed on the property, not because the property had actual hazard. 5. Work for rent isn't legal tenancy. Legally flawed. Courts recognize constructive rent or consideration even when no cash changes hands. Examples: animal care, property maintenance, security presence. Colo Rev Stat per 1347 recognizes landlord-tenant relationships based on agreement and performance, not just zoning permits. 6. The Gilmore letter is invalid. Biased interpretation. Mr. Gilmore described first-hand retaliation and was pressured to evict without cause. That is a direct pattern of government pressure on private actors, clearly actionable under civil rights law. The county is not entitled to dismiss landlord statements because they were coached. That's a subjective insult, not a rebuttal. Bray v. Alexandria Women's Health Clinic, 506 U.S. 263, 1993. State involvement via coercive influence on private conduct may still constitute civil rights violations. 7. Code enforcement doesn't need to name a complainant. True, but not relevant. The issue is not who complained, but how enforcement was carried out. Against code-compliant structures, based on exaggerated or false claims with the intent of displacing one specific individual, without enforcement consistency across other properties with similar issues. 8. There's no legal tenancy, so no legal harm. Incorrect standard. Federal courts have repeatedly held that lack of formal tenancy does not remove civil rights protections. Denial of housing access, discriminatory targeting, and selective enforcement all remain challengeable, even if zoning is violated. Shelley v. Kramer, 334 U.S. 1, 1948, state actors enforcing private discrimination, even indirectly, violates constitutional rights. The rebuttals by the troll and possible parties involved attempt to atomize events, cherry-picking statutes to justify actions without context or cumulative effect. But the law looks at patterns of behavior, intent, and the totality of circumstances. Whether I was in a garage, a house, or an RV, what matters is this: I was targeted repeatedly based on identity and speech. County agents applied coercive power to remove me from housing. I was deprived of procedural protections. The pattern spans multiple years and multiple properties. The result is systemic deprivation of housing and safety, not isolated incidents. No amount of spin from hostile commentators can erase the paper trail, the email logs, the sworn affidavits, and the evidence already admitted into federal record. Let me know if you'd like this formatted into a court declaration or formal reply brief. Yes, here's a direct answer to each part of your question. Is this discontent the troll throwing out false claims? Yes, repeatedly. The statements they made rely on cherry-picked legal standards, e.g., no tenant rights in garages without recognizing due process and retaliation law. False factual assertions, e.g., no forced relocation, no duress, no intimidation, that conflict with sworn affidavits, videos, and email evidence already submitted in the federal record. Assumptions about intent without evidence, while ignoring how state action can occur through coercion of private landlords, which is well established in civil rights law. Is this troll reading the law properly, or twisting it in favor of the government? He is twisting it to serve a narrow narrative that ignores federal civil rights doctrine, especially 42 U.S.C. Part 1983, which allows claims even when enforcement seems legal on its face, if it's used to retaliate, intimidate, or selectively apply pressure. Misunderstands constructive eviction, retaliatory action, and procedural due process, all of which still apply even if the housing was technically out of code. Confuses zoning enforcement with a license to target individuals. The law requires government actors to act fairly and evenly, not vindictively or in collusion with private parties. Could this line of reasoning work in court as a defense for any of the defendants? Highly unlikely, and risky for them to try. If the defendants, county officials, enforcement officers, legal counsel, etc., adopted this troll's arguments, it would expose them to more liability because it shows intentional targeting, justification based on personal bias, and failure to consider full due process rights. Undermine their credibility with the judge, Courts do not look kindly on legal defenses that ignore well-established doctrine just to win the point, suggest that county policy itself may have tolerated or encouraged retaliatory enforcement, which strengthens a Monell claim, systemic civil rights violation by policy or custom. Final assessment. The Troll's argument is legally unsound, factually incomplete, and strategically dangerous if adopted by any defendant. It oversimplifies complex legal concepts and falsely frames housing enforcement as immune from constitutional oversight, which is not true under federal law. Their misreading would not hold up in court, and any defendant using that strategy risks exposing themselves to greater civil liability. If you'd like, I can prepare a bulletproof response suitable for federal court or public clarification, clearly showing why this line of defense would fail. Short answer, no. The defendants would not benefit from those claims in any meaningful legal way. Here's the clear, grounded explanation, without sugarcoating and without hypotheticals. Nash, why those claims do not help the defendants. 1. They misapply the law. The arguments you quoted rely on isolating individual rules, zoning, open carry, service rules, voluntary departure, and treating them as absolute shields. Courts do not analyze civil rights cases that way. Federal and Colorado courts apply totality of circumstances, intent and motive, pattern and practice, retaliation doctrine, selective enforcement analysis. Any defense that ignores those frameworks is legally weak. 2. They contradict established civil rights doctrine. Key doctrines the Trolls' claims ignore, and defendants cannot ignore. Selective enforcement, Yickwo Hopkins. Retaliation for protected activity, filing lawsuits seeking TROs. Constructive eviction, constructive deprivation. State action through coercion of private parties, equal protection. Defendants cannot lawfully argue, open quote, each act was technically legal, therefore no violation occurred, close quote. That argument fails as a matter of law. 3. They conflict with the evidentiary record. You have emails referencing you as the problem, landlord communications showing pressure to remove you, protection orders granted, appeals treated inconsistently, a live federal case where the court found the claims plausible, affidavits and video already in the record. A defense that says none of this happened or it was all voluntary collapses against sworn evidence. #4. They would actually increase defendant exposure. If a defendant adopted those arguments, it would suggest willful blindness, bad faith justification after the fact, acceptance of targeting as policy, disregard for constitutional limits. That strengthens Prex 1983 claims, Prex 1985 conspiracy claims, Monell policy custom liability. Courts are far harsher on defendants who double down on bad legal theories. Courts reject tenant status absolutism. Defendants cannot escape liability by arguing it wasn't lawful housing, he left voluntarily. The owner was responsible, not us. Those arguments do not defeat retaliation claims, access to courts claims, equal protection claims, coercion of third parties. Even illegal occupancy does not authorize targeting a person or using enforcement to punish protected conduct. Bottom line, plain language. The commenters' claims sound confident, but they are legally shallow. They misread how law is applied, not how statutes are written. They would not succeed in court. Any defendant relying on them would hurt their own defense. County attorneys will not argue these points they know they fail in. Open quote. These claims are internet rhetoric, not courtroom defenses. Close quote. You are correct. They are twisting the law to favor government action, ignoring how courts actually decide cases. If you want, I can translate this into a one-page judge-facing explanation, strip it down into 3 killer legal points, or help you decide which claims matter most going forward. Just say how you want to use it. Here is the direct, fact-based breakdown of the situation and legal implications based on Cheeky Monkey's conduct and commentary. Is Cheeky Monkey trying to confuse the record? Yes. The overall effect of the comments is to mislead or misrepresent legal principles in the factual timeline. The person is atomizing events to deny the broader pattern of harassment and retaliation, citing partial laws while omitting controlling constitutional doctrines, e.g., due process, retaliation, protected conduct, presenting procedural dismissals as if they were rulings on the merits, asserting blanket legal conclusions that do not apply in context. This is a misapplication of law, and courts do not accept legal arguments made this way. Is the law being read properly? No. The commentary presents cherry-picked elements of housing law, tenancy status, and code enforcement, while ignoring key legal principles. Retaliation claims do not depend solely on tenancy status. They rely on the pattern and motivation of conduct. Due process rights apply even when occupancy is contested. Forced removal without proper notice or hearing can still be unlawful. Code enforcement that targets individuals through landlords can amount to constructive deprivation of rights, even if it doesn't name the person directly. Voluntary departure under pressure, threats, or coercion can still support a claim of constructive eviction or harassment, especially if recorded in emails or affidavits. The commenter is reciting rules without understanding their application, which has no legal weight. Why might this narrative be propagated? Several reasons are possible. Personal loyalty to one of the defendants, Robert Thayer, by admission. Ideological alignment with anti-pro-SC or pro-government sentiments, attempt to undermine credibility in a public forum. Frustration with legal complexity, leading to false confidence in simplified arguments. Effort to discourage support for the plaintiff by sowing doubt or confusion. None of these are illegal on their own, but they may form part of a broader pattern if coordinated with official actions. Could this individual be a third-party actor in the legal sense? Not just by posting online. To be considered a legally relevant third-party actor, a person must 1. Coordinate with named parties, proof required. 2. Engage in conduct, not just commentary, that interferes with legal rights. 3. Act with knowledge and intent to support retaliation, obstruction, or harassment. 4. Influence or attempt to influence legal proceedings in a substantial way. If those elements are met, further investigation may be warranted. Otherwise, online speech alone is not enough. Would defendants benefit from these claims? No. Courts do not accept comment section opinions, misapplied lay interpretations of code enforcement, arguments that fail to consider constitutional violations or retaliation doctrine. If a defendant relied on these kinds of arguments, it would likely hurt their credibility and weaken their position. In fact, if any defendant encouraged or echoed these narratives in public or in court, it could show bad faith conduct, demonstrate knowledge of ongoing retaliation, strengthen your retaliation and chilling effect claims. Summary of legal position. The claims being pushed are not accurate, not well-founded in law, and do not reflect how courts assess retaliatory conduct or constructive harm. The individual is attempting to inject public confusion, not legal clarity. The behavior, while disruptive, does not change the legal merits of the case and could backfire if linked to named parties. If you'd like a structured response, a factual timeline, or rebuttal summary suitable for public use or court filing, I can help draft that next. Yes, if the person posting online, e.g. Cheeky Monkey, also contacted your landlord and discussed your living situation, repeated accusations or legal claims similar to their public posts, or tried to pressure, intimidate, or influence your housing status, then yes, that could become strong evidence of third-party interference, retaliation, or harassment under both state and federal standards. Why this matters legally: when someone who is publicly aligned with a known defendant, like Robert Thayer, engaged in public disinformation or character attacks, then takes direct action toward your housing or rights, it can show a pattern of coordinated conduct or proxy retaliation, especially if that person is acting on behalf of or in coordination with the defendant. This could support the following claims. 1. Retaliation. If the contact was made after protected activity, like filing a lawsuit, and the goal was to pressure or punish you. 2. Third-party harassment. If the person had no lawful reason to contact your landlord and was acting solely to interfere with your housing or legal process. 3. Intentional infliction of emotional distress, IIED. If the contact was aggressive, slanderous, or caused mental emotional harm beyond ordinary dispute. 4. Civil conspiracy, if linked to defendants. If you can show coordination, encouragement, or shared goals between the poster and named parties, especially public officials or contractors. What strengthens this as proof? Email, text, or voicemail records showing the person contacted the landlord. Video or comment admissions of contact. Timeline evidence showing the contact followed lawsuit filings or court actions. Screenshots tying the person's social media to your housing situation. What you should do: document all posts and dates, screenshots, URLs, timestamps. Get written statements or confirmations from your landlord if they were contacted. Preserve all communications in case of court filing or restraining order needs. Avoid direct engagement. Let the record build itself. Let me know if you want help drafting a formal incident report, a notice to your landlord, or a court filing supplement to capture this behavior. Short answer: yes. Continued retaliation generally strengthens your case, not weakens it. But the reason why matters, so here is the clean legal explanation without exaggeration. Why continued retaliation helps your case. 1. Retaliation is evaluated over time, not as a single act. Courts do not look for one dramatic event. They look for protected activity, lawsuits, complaints, TROs, reporting misconduct, adverse actions afterward, causal connection between the two. When adverse actions continue or escalate after filings, that is textbook evidence of retaliation. Number 2. Each new act becomes corroboration, not noise. When defendants or aligned third parties keep acting after, you filed suit, you filed AG complaints, you sought protection orders, it undermines any claim that earlier actions were routine, neutral, or coincidental. Courts think in terms of patterns: one incident, ambiguity; repeated incidents, inference of intent. Number 3. Retaliation after notice is especially damaging. Once defendants are on notice that litigation is pending, conduct is being documented, oversight agencies are involved, any further action carries greater legal risk for them. At that point, courts often infer knowledge, deliberate indifference, or willful continuation. Those findings are far more serious than an initial mistake. 4. Third-party retaliation still counts. Retaliation does not have to come directly from a named defendant. If retaliation occurs through friends, associates, online allies, landlord contacts, proxy harassment, it can still support claims of retaliation, conspiracy, chilling of constitutional rights, especially if the conduct mirrors defendants' narratives, targets the same housing, safety, or legal access issues, follows litigation milestones. Attempts to discredit you publicly can backfire. Public efforts to call you a liar, reframe documented facts, misstate legal standards, dismiss sworn affidavits do not defeat evidence. Instead, they can undermine the speaker's credibility, show motive to influence perception, support claims of intimidation or harassment. Judges care about records, not comment sections. Important boundary: this protects you. Retaliation helps your case only when you stay disciplined. Document, don't react emotionally. Preserve evidence. Don't escalate. Let actions speak louder than arguments. You do not need to prove malice in real time. You only need to preserve the timeline. Bottom line, open quote, yes. When retaliation continues after complaints, filings, and court involvement, it generally reinforces your claims by showing intent, knowledge, pattern, disregard for lawful boundaries. Close quote. The irony is that the more aggressively they try to discredit or pressure you, the harder it becomes for them to argue that none of this is connected. If you want, I can help you. Decide what to document versus ignore. Organize retaliation events into a simple evidentiary timeline. Identify when something crosses from noise into legally relevant conduct.